everybody for coming along. It's a great privilege for us to have Professor Sam Ricketson here. He's a very distinguished Professor of Intellectual Property Law and practitioner, and he wrote the definitive work on the Berne Convention and is now working on the Paris Convention. So thank you, Sam.
Thank you very much, Julia. It's very, very nice to be back here and to be speaking to you. I understand that apart from those who I've already met who either on the staff or do a PhD, the bulk of you would be undertaking courses in the Master's program in either international IP or in IP generally or WTO law. The matters that I wanted to talk about today were really directed at the way in which one carries on research or why one carries on research in this particular area. One always has to ask that question, particularly when you start a project such as the one I've been working on recently. Why are you doing it? What is it going to achieve? I found it was easier when I was doing my Berne work in that was a more focused and concentrated convention. And the time that I was doing it, history had largely stood still so far as the Berne Convention was concerned, and the Uruguay round hadn't started. Various countries were still outside Berne, and it was very much a static situation that changed only too rapidly immediately afterwards. But nonetheless, there is a corpus, a focus that one can have in working in that area. Paris is perhaps rather different because it's a much more multi-layered or multi-compartmentalised convention that deals with all the other aspects of industrial property. It's therefore nowhere as successful, I suppose you could say, as the Berne Convention is in establishing international norms. But it does have some real successes or achievements nonetheless to its credit. To me, it does seem an important exercise to look at the way in which these particular conventions came into being. One can talk about history and its value in understanding the development of legal systems and legal rights, and I'm sure in the presence of someone like Bill Cornish, he would only endorse that history casts great light on the present and the way that we might deal with things in the future. That's perhaps just an obvious thing to say, but in the case of the intellectual property conventions, Berne, Paris and all the related conventions, it is really important to understand their genesis and the way they've developed in order then to see how they do have some application to the present in very practical terms. That can be important, but also in what happens in the future and the way things might be done. And I think there are important lessons to be learnt there. Can I also say that as someone who's always been a thwarted historian, someone who likes to delve into some of the deep uncovered burrows of things, there can be a lot of fun in doing this. I had some further comments of a more general character that I wished to make, which were just to indicate that this should not be and should never be just an exercise in legal analysis or even more broadly in legal history, because there are much wider dimensions to any analysis, any inquiry into any matter related to these international conventions. I've just listed several of them for you, but there are some really important intersections here that one needs to be aware of. These are agreements in public international law, and they have many interesting characteristics that are more broadly of relevance in public international law. They also have some intriguing private international law issues in that once you have studied and come to grips with the conventions, you realise that there's a whole world out there that is not dealt with by these public international law instruments, which is the way in which matters are to be dealt with at the personal level, conflict of laws, jurisdiction, and the like. There are, of course, as you'd all be aware, the much wider economic, social and cultural contexts in which all these matters arise, and I've just noted some of them very briefly for you there, but in each of Bern and Paris one finds some fascinating debates that occurred and have continued to occur right throughout their history. And finally, and this is something which I've always been conscious of, but thought there is tremendous scope for people to do work. Perhaps it's more someone from a political science perspective or international relations perspective, but it's all part of the greater mix, which is the institutional and political aspects of these conventions. And I'll talk a little bit more about that at the end, but I think there is enormous scope for people who might be wanting to pursue multidisciplinary, interdisciplinary research projects in this area to look at some of these institutional aspects and even, dare I say it, some of the biographical aspects that I think would be quite intriguing to pursue. I thought it would also be useful just to say something very generally about the practicalities of research in this area, if only to indicate just how much more easy it is to do these days than it was when I began doing some of this work in the 1980s, and that's not that long ago. If one's simply looking at it from the point of view of the development of each of these conventions, they're venerable. They've been through multiple revisions, and they have generated in their wake significant volumes of material relating to the actual conference proceedings, which give, if one's so minded to read them, very useful insights into what parties were thinking, what they meant when they were talking about particular things, and how they might have come up with particular formulations. So there is an enormous body of that sort of material, but particularly in recent years, each diplomatic conference or revision conference has been preceded usually by very significant preparatory meetings, which again generated a huge volume of material. And I'm just here talking about the international materials that are available, which are, in terms of treaty interpretation, going to be the most critical materials. There are huge volumes of them to be aware of and to consult. There are also the government records of particular parties who took place in the negotiations, and there are considerable bodies of material to be found, particularly in this country. I've really only looked at this country in detail and at Australia, but of course each of you who've come from other countries would be aware of the materials that might be available there, and which could really cast light on the attitude of your government in their particular negotiations. And then there has been, really until the mid-1990s, an unending source of material that's been generated by the international offices that were established under the conventions. Copyright, which goes back to 1887 in French and then in English from 1965. Industrial property, which goes back even earlier, and in English since 1960-61. And one's often impressed when you look at these journals, particularly the early ones, that they were the productions of meticulous, dare I say, almost anally retentive individuals who recorded everything and published everything they could about the convention, national laws, the resolutions of relevant organisations, what we'd call lobby groups, civil society groups today. There is a huge volume of material there. It really begins to fall away, in fact, from the mid-90s, where other publications take over of a more populist kind in WIPO, but there is, as I should emphasise to you, an enormous volume of very relevant and interesting material there. And of course there are contemporary accounts and commentaries, particularly on Bern, but also on Paris, some in English, most in other languages such as French and German. And the wonderful thing that you have today is that most of these things are now online, whereas in the 1980s and indeed up to the really late 1990s, they were only available if you were able to consult libraries. Not all of them were available in this country at that time, I can say. Most of them are available in places like Max Planck or in Geneva or in Washington. But digital technology has made a huge difference there. And I've just given you one particularly valuable web link there, which is to the WIPO archives. It's not actually easy to find if you go to the archive, to the website itself, but that link will take you to there. And you'll find that almost all the records of the diplomatic conferences for Bern, Paris, Madrid, and some of the other conferences are to be found there. And that's just an enormous facility or resource to have. Likewise, there's a lot of 19th and early 20th century French language material available from the Bibliothèque Nationale at the Gallica website that I've given you, as well as past copies of industrial property, but many other things. There's a lot that's available for purposes of resource and the research. And then I finally referred to something that I'm sure you're all familiar with if you've done any research, British parliamentary papers. And that's really just a starting point, but just to indicate to you how much easier it is to conduct research in this area. So that really comments by way of overview as to what's in the area, the materials that are there, that do enable very narrow inquiries into particular things, but also do allow for wider ranging investigations. So I thought I would just say a little bit now about the Paris Convention as a case study as to the issues and problems that arise in relation to doing research on an international convention such as this. And as I mentioned at the outset, it really has quite different dimensions to it than the Bern Convention, which is more focused on authors' rights, and really that's it. Paris, on the other hand, is a much more wide-ranging convention in terms of subject matter, and at one level it will appear to be very disappointing because of its lack of substantive norms. On the other hand, it is enormously significant even now because it does establish, through the principle of national treatment and through the priority system, the basis for the protection of industrial property rights internationally. And that achievement, as early as 1883, was very considerable, and that still continues to underpin the basic system today. And it's interesting to appreciate the significance of that achievement when you look at what was the case prior to 1883. By that stage, most countries had developed national laws on protection of patents, trademarks, designs, to some extent unfair competition. This was an area that had become quite hotly debated, as you might be aware, in national fora. There were, in a number of countries, very strong philosophical and theoretical arguments about whether or not one should have patent protection. That perhaps was the most significant area of controversy. That debate never really reached the point of abolition in this country, although it was caught up with some very strong arguments about the need for administrative reform and the like. But it did reach a point in some countries where, in fact, patent laws were abolished. The Netherlands is perhaps the most significant case in 1869. There was a recommendation from Bismarck to the Prussian Parliament that something similar should be done there. That was not ultimately acted upon. But it gives you some idea as to the intensity of the arguments that went on, and really these were matters of great public debate. And I have a reference there to work that was done by a PhD student of mine. In fact, Bill was one of the examiners, Louise Duncan, which is still unpublished, but is probably one of the most exhaustive treatment of these debates that occurred in this country, in France, Germany, Netherlands, and other European countries at the time. So patents was a hot issue. Trademarks, I think, probably weren't quite so much to the same extent, but there were real concerns, particularly in this country, when they were exporting things, that their goods, or that there were being misuses of well-known British trademarks in other countries who weren't protecting them. Designs was yet another. Now, these are all the concerns that begin to push countries towards entering into some kind of international agreement with other countries for mutual protection. Bilateral agreements began to occur, but they were largely piecemeal. They differed in their content and how far they went. And the notion that there should be some multilateral agreement, which would now seem to us to be completely obvious. We live in a world of multilateral agreements. It's been something that's been part of the world makeup for at least the last 100 years. But in the late 1870s, early 1880s, this was a comparatively new and revolutionary notion. And I can use the word revolutionary because there weren't many other significant multilateral agreements dealing with what you might call matters of private law, indeed even of public law. Two particular models, I suppose, for the Berne and the Paris Conventions were what was done in respect of posts, the Universal Postal Union, which meant that you get a letter from one side of the world to the other, the International Telegraph Union. Both those conventions precede Berne and Paris by about 10 or 20 years. Things as mundane as weights and measures and other kinds of health issues. And then towards the end of the 19th century, we begin to see the various Geneva peace agreements that were entered into. So multilateralism was beginning, and Paris and Berne and intellectual property rights were part of that. There was also, I think, an interesting connection here with the desire of countries as they began to industrialise, and here we are talking about the industrialising countries, to show off and to exhibit what they were achieving. The holding of international exhibitions became a very popular pastime in the second half of the 19th century, beginning with the Great Exhibition in 1851 in this country. And there was an interesting connection here with the need to have some kind of international protection for international exhibitors coming here who didn't want to lose protection. They subsequently applied for patent protection or designs protection here, that they should get some temporary protection. In fact, we might now call that as something rather similar to a provisional patent specification. So the notion of that we had to be aware of what was happening elsewhere, or if we wanted to exhibit our goods elsewhere, we needed to be protected, began at that particular exhibition. Then was picked up for every other international exhibition that occurred throughout Europe and then North America at the time, where some kind of temporary protection for international exhibitors would be required. And indeed, that's one of the first provisions that you find in the Paris Convention, continues in almost the same form today. But that's only just the start. Coming out of these exhibitions, there were also parallel congresses that were held in Vienna in 1873 and in Paris in 1878 that were specifically devoted towards patents and more generally industrial property. The one in Vienna is a fascinating exercise. It was largely, I think, dominated by German-speaking countries, but there was a significant British and American involvement. And for the first time, you began to see systematic discussion of the need for the adoption of a multilateral agreement, not just simple bilateral or temporary agreements, as you had with these exhibitions, but something that had a multilateral character. And that conversation was continued and taken perhaps to a higher level at the next international exhibition in Paris in 1878, and that indeed led to the French government being asked to, and the French government acceding to the invitation to convoke the diplomatic conference in Paris in 1880, that then led to the adoption of the Paris Convention. So at that instance, it really was a French initiative, but the initiative had been pushed along by this work that was occurring at these international congresses. And there were interesting people concerned, and some of that background is very well done and described by Louise Duncan in her thesis, where she talks about some of the personalities involved who were able to cross borders and create the atmosphere, I suppose, or the intellectual atmosphere that led to the French government being prepared to take up this invitation. You can identify some different strains of thought at this stage. I've noted several of them in the dot points. There were, of course, the idealists, those who looked for some kind of universal law that might be achieved. Perhaps they would have found, the European patent or the European trademark a model, but a world patent and trademark. That was obviously not possible, but the more interesting development was what I would call the pragmatists, or those who saw we should simply aim at getting protection of any sort in other countries through the instrument of national treatment. And if there are to be some more substantive requirements as to what that protection should be, that should be a matter for addition at a later stage. So there will be revision, and revision has been built into the Paris Convention and the Berne Convention from the very start. So it was seen as a dynamic instrument, and it was one that was to be regularly revised. And I have noted there the number of revisions that have occurred in relation to Paris. The ones that are bolded are the ones where a new act of the convention has actually been negotiated and adopted that would replace, ultimately, that which went before. But what's interesting is to see that there was a rush towards revision, even as Paris was negotiated and signed in 1883. The delegates said, we'll meet again in Rome in 1886, and we'll have an even more thoroughgoing set of proposals that we're going to incorporate. That just didn't happen. They had the meeting, which is all very pleasant, but no one was prepared to agree to the next step. That again happened in Madrid in 1890, and with some very limited steps forward. Brussels in 1900, there was an agreement on what was called an additional act, which largely dealt with matters of interpretation. So it wasn't really till you have the bolded ones, Washington 1911, Hague 1925, London 34, Lisbon 58 and Stockholm 67, that you have what you could really call revisions and adoptions of new texts. Even that's quite significant. It's probably worth noting, however, that even in Madrid in 1890, the first of what I call the side agreements was adopted, the two Madrid treaties that deal with indications of source and international registration of trademarks. And likewise in The Hague in 1925, a separate agreement dealing with international deposit or registration of designs. So there were some quite significant textual achievements that came out of these conferences, even if the actual revisions to the Paris text itself might have been relatively limited. The other thing, perhaps to just note in passing, and this is where I think it's fascinating to go into some of the records, but there was very real influence by a number of countries at different times. I've mentioned France in the case of the Paris Convention, the Paris Act of 1883, but the US government in 1911. And indeed, there's a fascinating story just to see the trajectory of US engagements with the Paris Convention over the next few conferences, because they would often have been pushing for particular proposals, but more often than not were unsuccessful. But then when something was adopted, it was always interesting to see that the US delegate would make a very clear statement as to how they would interpret that particular provision. So interesting from the point of view of treaty interpretation. And I think it would be a fascinating exercise to go back through US diplomatic records looking at instructions to delegates. The other interesting aspects are to note the beginning of the influence of what I call non-governmental international organisations. The most obvious one is the International Association for Protection of Industrial Property, or AIPPI, which doesn't start until the late 1890s, but then became almost the preliminary meeting for revisions of the Paris Convention. They would put up proposals, recommendations, and these would all appear in the texts of the records of the diplomatic conferences, and often reference would be made to these, and often AIPPI delegates would be asked, observers would be asked to speak or contribute. The International Chamber of Commerce is another very influential body, so this will give you some idea. This was the club of industrialised countries at this stage. But what I think is fascinating is in the 20s to see the engagement of the League of Nations and the Economic Committee of the League of Nations. And it had quite a broad brief. It looked at a number of matters of private law. It was obviously concerned with issues that had a more public law aspect, like labour laws and anti-slavery laws, but also was very concerned to try and develop a draft law on unfair competition with a direct view to feeding that in to the Paris Convention, the adoption of what we now have in Article 10 bis, although that had come into the Paris Convention a little earlier, but to flesh that out. And I should just note there's one fascinating figure who I have to say I was unaware of until very recently, a man called Sir Hubert Llewellyn Smith. Now, I'm sure, anyone heard of him? No. Well, this is one of the great and significant figures of British civil administration of the late 19th and early 20th centuries. He was, I think he was actually a graduate of this university, but that probably has nothing to do with his much greater success later on. But he was, or perhaps it's an indication that he could only have been successful with that background. But he was involved in labour reforms and labour relations, then ended up in the Board of Trade. He was a statistician as much as anything, and he worked with people like Booth and the Webbs in the East End, but ended up in the Board of Trade as head of the Board of Trade, actually under the period of Asquith and Lloyd George, and then became Chief Economic Advisor, I think possibly the first Chief Economic Advisor to the British government in the 1920s, and a regular delegate to the League of Nations, and in fact was head of the British delegation to the Hague Revision Conference of the Paris Convention. And he was the man who was, as I gather, largely behind the formulation of this law of unfair competition. And I think he's a man who really does deserve some extended historical research. He's got quite an interesting biography in the National Dictionary of Biography, but I think he was a man who seems to have had his finger in so many pies, but particularly in the League of Nations. And that body did have quite a considerable impact at the time. So just to pass on beyond those revisions, the last of those revisions in 1967 in Stockholm perhaps isn't a revision at all, but it's really by way of being a major restructuring of all the administrative and financial provisions of the Paris and the Bern Conventions and the other associated conventions, but nonetheless significant for all that. If one was to look at the significance of the Paris Convention following that Stockholm text, which was adopted in 1967, it is a very mixed story. In fact, it's almost a story of tragedy with some limited triumphs. There have been triumphs, and I think this is something which, as a practical lawyer, one ought to note. The classification agreements, things that you would use every day if you're in trademark or patent practice, come back to the work of WIPO and BURP as it then was, and ultimately come out of the Paris Convention. The procedural advances that are embodied in the PCT and the Madrid Protocol, achieving common pathways, which really makes much greater sense of the priority system under Paris. These are really quite considerable achievements, and I think they do ultimately go back to the work of several men, and I'll talk about those briefly in a moment. So those are very positive things that I think would have to be noted and really do provide some considerable content to the international system. But then there are the monumental failures, and I think these can only be called monumental. There was an attempt to revise the Paris Convention in 1880 to 1980 to 83. 4 diplomatic conferences held in successive years, hundreds of people involved. They lasted for a month on each occasion. At the end of the first one, on the penultimate day, they had agreed on voting. So they said, we'll come back next year. And they went to Nairobi, and they had another month, nothing agreed. And they went again and again and again. And that whole process ran into the sands. Now, it ran into the sands over the very issues that you'd be very much aware of continue today, the division between developing and developed countries, particularly over compulsory licences. But it is a really sad story to read and to look at the documents, particularly the last documents, as they have meetings after 1984 to consider what to be done. And it really does have an air of tragedy about it. There were also attempts at what you might call carving things up a bit, taking one area and developing new norms in that. Patents. There was even another diplomatic conference in 1990 or 91, I might have that wrong, that had quite an ambitious set of proposals that would be in addition to the Paris Convention, that fell down ultimately not because of the developed country split, but because of split between first to filers and first to invents, among other things. The US on one side, other industrialised countries on the other. So these are quite sad events if you look at it in the overall sense. And there are other failed initiatives, of course, by the World Intellectual Property Organisation at this stage, which you may have touched upon in your classes. On the other hand, the efforts that have followed since then have been rather more targeted and rather more limited to procedural harmonisation, a worthy thing, a much narrower focus, and where there might be room for agreement, and there are agreements that have been reached in patents and trademarks in relation to that matter. But I think what is perhaps an interesting collateral achievement, which may affect nothing on the Paris Convention or WIPO, but is that it incorporates the trade standard into TRIPS, and you'll be very aware of that if you're undertaking the WTO class. So it's a mixed story if one thinks of it in terms of achievements or defeats, and of course other factors have now come into play much more sharply. The development agenda is now very strong within WIPO and other agencies, and that has all sorts of implications for patents, for other rights. And wider issues now, of course, have become very important, public health, human rights issues, and so on. So at the end of it, I would have to say it's hardly an irrelevance, the Paris Convention, but it remains crucially important, at least in providing a bedrock, and we had some interesting discussion of that a couple of nights ago in London. I was talking to public international lawyers about that. but it's a tattered rag, I suppose one would have to say, compared with perhaps the Berne Convention, which has a more complete coverage, although, of course, not necessarily in the digital age. Is there a system that Paris embodies? Well, I have sought to try and set out a system in the diagrammatic representation on the last page. I think it might only satisfy those who like to see things visually and think, well, it must all be there. But there are some flow-ons that you can see working from Paris, starting off with national treatment, some subject matter that deals with, which I think also does reveal to you the real problems that there are in a convention that actually tries to go so wide, and might well explain why there's been so limited development that's been made in the area of substantive norms. It is disappointing, I suppose, if you start to look at it and you think, well, if this is dealing with industrial property, surely it should tell us what a patent is. No, it doesn't. Surely it should tell you what a design is. No, it doesn't. Surely it should tell you what a trademark is. Well, it does to a limited extent. It does tell you to some extent what unfair competition is, and that's perhaps one of the most interesting aspects of the convention. But it is essentially unsatisfactory. It's like a framework with gaps in it, and the gaps have to be filled out. And then, of course, there's going to be contention as to how those gaps should be completed. Now, I can see that I've probably gone a little close to time. What time did you want to finish?
We probably should finish around 2.
Oh, I see, yeah. Okay, because the two further matters that I wanted to touch on briefly, but I'll just touch on them briefly now. If there's any questions or comments or criticisms, please raise them. First of all, I did want to draw your attention to what I call the more peculiar or particular public international law questions that arise in relation to the Paris Convention and the Berne Convention. And just that I've listed a number of them there, but one that I think is really intriguing is the concept of union. The Paris Convention establishes a union for the protection of industrial property. What does union mean? Does it have any content? Is it establishing some kind of separate entity with an international legal personality? Well, the convention does establish organs, an assembly, executive committee, international office. It does have finances and contributions. All those might be features of something that has international legal personality. But in fact, and in practice today, all that is subsumed under the aegis of one larger, truly international organisation, which is the WIPO. Is it simply a statement of aspiration? What's the aspiration? That industrial property protected? Well, I suppose that's true. But there might be one area where it does have a little work to do. And this is intriguing, but possibly, like many issues, not of immediate practical importance. But you will recall that the convention has been subjected to regular revision. And there is the possibility, and this was one that existed more in previous years, of having states that belong to earlier texts that have not adhered to the latest text, and other states that have adhered only to the latest text. And in treaty terms, that raises an interesting issue. They have no treaty relations. Now, there are some attempts at answering that to be found in the latest text of the Paris Convention, which says essentially new states have to apply to non-party states to this particular text, the earliest text that party was bound by. So there is some connection. You can require that of someone joining the latest text, but there's no obligation on the non-party because there's no treaty. Now, it doesn't ever seem to be an issue, I think I can say that, but it could have been an issue at earlier times, particularly if the latest text had a lower level of protection, the earlier text had a higher level of protection. One answer to saying that they each have obligations, and a colleague at the British Institute described this as possibly a non-reciprocal obligation, because the party to the earlier text has no obligation to a party to the later text if there's no text in common. But one answer might be, well, they're all part of a union, so it's an organic whole. So they're like members of a company, members of a corporation. So it's an intriguing and possibly ultimately unproductive area in which to inquire, but I still would like to have an answer. Maybe there isn't. So that's one thing. One other, or two other matters just draw your attention to. There are fascinating issues that arise if you're interested in treaty succession and the way in which states, newly independent states, succeed to relations under the new text. And there are also, I think, some very interesting issues that arise as to treaty application, and this not going to be an issue, I think, for a country such as ours, where you need to have some kind of domestic implementation, but for countries where treaties are capable of direct implementation, there must be issues that arise with some provisions of Paris and of Berne. They are capable of being directly implemented by going to the courts of that country, at least in theory. Some aren't. How are those matters dealt with? I think these are matters that are probably best dealt with at the national level. You will know what your constitutional arrangements are for treaty implementation, but there are interesting questions that arise there. The final point I just raised at the bottom was some matters for further research. I think I've suggested some already, but I did say a little bit at the start about institutional issues. It seemed to me to be very interesting in this area. And I said biographical issues might also be interesting. There are some great histories to be pursued here, particularly the role of WIPO, its ups and downs, but also some of the figures involved. And I think one of the most interesting figures of the late 20th century was that of Dr. Arpad Boksh, who was the Director General of WIPO for many years and the author of some of these great successes and great failures. But there are also some other very interesting figures at an earlier time, a particular secretary who was Secretary General in the 1950s. So I think that's probably all I should say.
Thank you very much.